Ever felt stuck in a tough spot at work and just had no idea where to turn? Well, if you're in Taiwan, there's actually a powerful system designed specifically to help you out. So let's break down exactly how it works.
You know the feeling, right? Maybe your pay was docked out of nowhere, or you were let go without a good reason, or your hours just got slashed. It's a frustrating and honestly a pretty scary situation to be in.
Okay, let's make this real. Meet Alex. Alex is a really dedicated employee, but one day their whole world gets turned upside down. And they feel like it's just their word against a big company. I mean, what can they possibly do?
But this is where the story changes. Because you see, Alex isn't powerless at all. In Taiwan, there's a specific law called the Labor Incident Act, and it was created for exactly these kinds of situations. Trust me, it's a total game changer. So what is this act really? Well, at its core, and this is all laid out in Article 1, its whole purpose is to handle these disputes in a way that is fast, fair, and professional. It's not about these long, drawn-out battles. It's about finding a real, proper resolution. And the difference this act makes? It's huge. I mean, before, a workplace dispute meant a trip to the traditional court system. That path was often incredibly slow, really complex, and super expensive. Now, the entire system is built around a much faster, more accessible first step. So, what is that crucial first step? Well, before you even think about lawsuits, the law requires something called mandatory mediation. Yeah, Article 16 of the Act makes it super clear. For most labor cases, you can't just go and sue your employer. The required first step, the journey's beginning, is labor mediation. And this isn't just a suggestion, it's the required path you have to take. So how does this whole journey start? It's actually a pretty clear three-step process. First, you file your case. Then, a special committee is put together just for you. And finally, you all meet to talk it out and hopefully find some common ground. Now, this mediation committee, it's really unique. It's not just some one person making a decision. Article 21 specifies this perfectly balanced team. You've got a judge, a labor relations expert, and a business relations expert. This makes sure the discussion is fair and really grounded in real-world experience from all sides. So, the Act doesn't just create a new process. It also gives workers some pretty powerful tools to make that process fairer. Let's take a look at what they are. First up, and this is a big one, the cost. Filing a court case can be really expensive, right? But under Article 12 of this Act, for major issues like unpaid wages, the worker only has to pay 1/3 of the usual court fees up front. That makes seeking justice so much more accessible. But wait, there's more. The whole process is designed to be fast, with the goal of wrapping things up within 3 months. You also get to choose a court that's convenient for you, like where you actually work. And, so importantly, the burden of proof gets shifted. Your employer is now required by law to provide those key documents. And this right here is such a critical point. It comes from Article 38. Basically, if your time card says you were there from 9 to 6, the law now presumes you were working that whole time. The burden is on the employer to prove otherwise, not on you to prove you were busy every single minute. So you've gone through the mediation, but what if you and your employer just can't see eye to eye? Well, the law has a clear plan for that too. There are really 3 main ways this can go. Best case scenario, you reach an agreement and boom, it's legally binding. Or, if you're really close, the expert committee can actually propose a solution. If nobody objects within 10 days, that plan becomes the official deal. And if there's truly no agreement to be found, the case doesn't just disappear. It automatically becomes a lawsuit, and you get to keep the same judge who already knows all the details. Okay, I know that was a lot of information, so let's just boil it down to the absolute essentials with a quick Q&A. Right, so if you're like Alex and you're facing a problem, what is the absolute #1 first thing you should do? Your first move, and honestly, your most powerful one, is filing for labor mediation. Don't even think about suing right away. Think mediation. It is the gateway to this entire system, and it's designed to be the quickest path to a fair solution. But why is this so much better than just heading to a regular court? What's the secret sauce here? It really all comes down to the people. That expert committee, that is the secret sauce. Having a labor expert and a business expert right there in the room with a judge, it just fundamentally changes the whole conversation. They get it. They understand all the little nuances of the workplace.
This is a really, really important question. What if you're out of a job, your income is just stopped, and you simply can't afford to wait months for a final decision?
The Act provides this incredible safety net for this exact fear. Under Article 49, you can actually ask the court for a temporary order. This could mean your employer has to keep paying your salary or even keep you on the job while the case is being decided. It's a vital lifeline. Okay, so after all of this, what's the one thing, the single main idea you should remember? Remember this, the Labor Incident Act is so much more than just some dry legal text. It's a practical toolkit. It gives people like Alex a real fighting chance to be heard fairly and to be heard quickly. It really does rebalance the scales. And the most important thing of all is just knowing that this toolkit exists for you.